Okay, I am going to begin. So, hello everyone. It's Lily again, and you are on track 4. So, I'm very pleased that we are hosting this talk today. So, I'll tell you a little story. A few years ago, I attended a webinar hosted by the American College of Physicians, and it was about disability evaluation. The speaker was a gentleman from the Social Security Disability Administration. And what really struck me about his talk was how much he emphasized to physicians that obtaining disability benefits was a life or death matter for many of his clients. If you couldn't obtain benefits, he had seen people not only not able to afford their medications or their healthcare treatments, he had also seen people lose their homes, unable to pay their rent, afford food, and so on. He was especially concerned because he had seen people hurt themselves when they couldn't obtain or maintain their benefits. So the topic today is really very important for a lot of patients, caregivers, and their families. So I'm pleased today to introduce Edward Dabdoub. Edward Dabdoub is the founder of the Dabdoub Law Firm, a law firm built for the sole purpose of helping people get their disability benefits from insurance companies. During his education at the University of Miami School of Law, he helped a man suffering from chronic pain obtain his long-term disability benefits after they were wrongly terminated. Since then, Eddie has dedicated his legal career to holding disability insurance companies accountable. He represents clients nationwide at all stages of disability insurance claims and has successfully litigated some of the most unique and complex disability insurance cases. Today, he will talk about how to effectively handle MECFS disability insurance claims. And for this talk, Eddie might stop during his slides and ask the audience if you have questions. And if you raise your hand, it's under the React button. I will unmute you and you can ask him questions verbally. Eddie?
Thank you for the introduction, Lily. I'm happy to be here. We spent a lot of time speaking about the medical side and the research with MECFS and more recently with long COVID, right? And what I am going to be speaking about is what happens when someone is unable to work because of these diseases. And there's a high incidence of disability as a result of MECFS and long COVID. It's very difficult for anybody to sustain long-term employment. And so disability benefits really becomes a lifeline for people facing that predicament. So as you mentioned, I welcome questions as we go through the slides. I want this to be as interactive as possible because it's a way of me imparting my experience and knowledge, not just in the world of disability, but specifically in MECFS disability claims. And the perspective is mostly going to be coming from a focus on insurance companies in the United States. But I think the talk in general is going to translate well into similar area of law, such as Social Security disability, which you had mentioned earlier. So I would say about 80% of the conversations and topics and the things where I'm going to be discussing will also pertain to Social Security disability. I want to start off by kind of addressing some of the common issues that we tend to see with disability insurance claims. And I preface it by saying what I have noticed is, in general, when someone is struggling from a disability and they have to submit a claim to an insurance company, it's automatically an uneven playing field, right? It's the ultimate David versus Goliath, right? And the person who is struggling with a serious medical condition is not equipped to take on a well-oiled insurance company that's willing to put a lot of time and resources into shooting down those claims, hoping these people just give up and go away. And then you compound that very basic dynamic with it's very difficult to find competent legal representation from someone who understands not just a specific practice area, but can go a few more layers into the onion of understanding the disease and the disease process and how it pertains to this practice area. So I want to speak about initially what are some of the core issues that we see in the legal world affecting our clients. One thing to be aware of, and most people don't know this, is many of the insurance policies floating out there, they don't offer coverage for disability benefit payments indefinitely, as they would for many other conditions. In fact, what they do is they tend, and there seems to be an increasing trend in the insurance industry where they're placing limitations, meaning 24 months payment periods or a cap in terms of the amount of payments somebody could get if they're disabled because of MECFS. The second issue that we tend to see, it's something that the insurance industry has been pushing ever since I started practicing law almost 20 years ago. And that is, they try to characterize the disability as purely subjective, right? And so you can't prove you're disabled because it's in your head and it's just what you are saying. And we'll talk about that some more. And they point out the lack of physical examination findings, the fact that MRIs or other type of traditional objective imaging isn't going to confirm the disease. Of course not. But the insurance companies have been using this tactic for a very long time. I'm going to address it, and then I'm also going to speak to what can be done about it. I think the third thing we've seen is treating doctors are very good, especially now, doctors who specialize in MECFS at understanding how to treat the patient. But they're not equipped, usually, not all. I've worked with many doctors and some really have figured out the game the insurance companies play. But generally speaking, a lot of doctors are not equipped to assist in navigating the disability process. And then last, it's remarkable to me that in all the years I've been doing this, I have not run into a single case yet where the insurance company has consulted a true expert on MECFS when reviewing someone's disability claim to determine if they qualify for benefits. And that really is, to me, telling. It's indicative of the insurance company knowingly burying its head in the sand, right? And what they're doing is they're going to internal medicine doctors, all sorts of different types of doctors, to solicit an opinion on someone's ability to function and work. But then when I test the doctor's credentials, they hardly, if at all, have any experience or expertise in MECFS or long COVID. So that kind of, those four things, I think, kind of capture some of the problems that one might face with a disability claim. I'm going to talk about another legal problem we have here in the United States. But before I do, I want to move on to just a few examples of what an insurance claim denial might look like, right? So if the insurance company denies a claim, what might be some of the things that they're communicating to people about the reasons for not paying the claim? And so the first one gives an example of the insurance company essentially declining to recognize someone's disabled from cognitive deficits, right? Typically, with MECFS, long COVID, as we know, there are going to be cognitive impairments. Most patients have cognitive impairments in varying degrees. And it's not something the insurance companies are keen to recognize, and they demand some sort of objective proof. So this first rationale at the top here kind of speaks to that. The second one in the middle essentially what the insurance company was saying is that examinations did not identify any physical findings. And then they go on to list some of the things that they would want to see. Although I believe in that particular case, some of those things were present and they were just misrepresenting that these things were not there. And then the second part of that denial rationale was that examinations did not support cognitive deficits due to an underlying neurological condition or other physical conditions, right? So it's the same kind of, they say it differently, but ultimately they're all saying the same thing. And then at the very bottom of the page, it's the insurance companies here saying reported symptoms, right? In other words, non-verifiable, subjective, when they use words like that in the insurance context. And limited examination and diagnostic findings. That's another way of saying it's not verifiable, it's purely subjective. Okay, so the situation as we can imagine it right now is the insurance company tries to cast IACFS long COVID disability claims as purely subjective, lacking objective evidence, so on and so forth. We're going to talk about why that's false and what we can do to overcome that. But here in the United States, we have an additional layer of a problem that stems from the law itself. Most disability insurance claims with insurance companies is governed by a federal statute, a US federal statute called ERISA. And that statute, when it was passed by the United States Congress in the 1970s, 74 to be precise, was meant to protect people rights to benefits, including disability benefits in case they became ill. But what has happened over the last 40 years is the law has, instead of developing in a way to protect folks, it has become more hostile to the disabled people. And that has then created an incentive for the insurance companies to start denying most of these claims. It's actually interesting because at our firm, we have seen a large increase in clients who have IACFS related disabilities, long COVID since the pandemic. So it seems like the insurance companies, as they get more claims for these conditions, are shooting them down even more. And so we've had to refine internally how we respond to those denials when a client comes in the door to us. A few problems with ERISA, just to create a visual on what we're up against here. We have a closed file review in litigation. What does that mean? It means in a normal case, if you are disabled and cannot work and an insurance company is not paying you benefits, in a normal kind of case, you get to bring into court any evidence you find will help prove you are disabled. It could be a friend, it could be a colleague, and they could testify. You could testify. You could explain what it's like to live a day in your life, in your shoes, waking up every day, not feeling like you had any rest, just this constant state of being worn down. You get to describe all this in your own words. You get to introduce anything that you think can help your case, and you get to present it to a jury. But in these ERISA cases, which represent about 80% of the cases we have in the United States with private insurance, you can't do that. Instead, the judge is only going to be looking at the file the insurance company has put together. So just papers, cold claim file, might not tell the story. And I think that's a big problem for us, because when you really spend time talking to people who are struggling and they tell their story, and if they were able to do that in front of a jury, the jury would then evaluate whether they feel for that person and believe what that person is communicating to be true and honest, and make a determination in that way. But the way the law is currently structured, the insurance company gets the benefit of this person not having the chance to tell their story, and instead reduces the entire case to be presented in front of a judge based on the insurance company's file. So That's one big issue. The second issue is there's no discovery. What does that mean? It means that in a normal kind of case, you can ask the insurance company, give me statistics on how many claims you denied when it's MECFS. You can really push their buttons to figure out what is it they're doing internally to target these types of cases, to show bad behavior. Now, in an ERISA case, that's extraordinarily difficult to get. And in many parts of the country, you're not going to even get a chance at doing that at all. So again, the law has created an incentive for the insurance companies to know we can act as bad as we want, because ultimately, if we get sued, it's very unlikely individuals will be able to try and get this stuff from us. We're protected by the law. No punitive damages, skipping ahead to number 4. Basically, in many states have laws that allows the plaintiff to not just get the benefits they should have gotten, but maybe additional compensation for what the insurance company had put them through. When it's an ERISA governed case, the Supreme Court has spoken to that issue years ago and said there shall be no additional compensation. If you win your lawsuit, you get the benefits you should have gotten in the first place. So again, incentive to insurance company to withhold benefits. And then the last part, the standard of review. I want to point out that a standard of review means that what is the process by which a federal judge is going to review your case? Is the judge going to review your case like a normal case to say, based on the totality of the evidence, the proof, the medical records, and everything else, I believe this person cannot work and therefore should be paid, or not? Typically, that's the way it works. But in an ERISA case, more times than not, the court will be applying what we call in law the arbitrary and capricious standard. The problem with this standard is it automatically gives a nod to the insurance company's decision not to pay benefits. The judge will actually defer, giving deference to the insurance company's decision, and it is our job to then prove that not just that the client cannot work, but we have to then go a step further and prove that the insurance company's decision to not pay the client had no medical basis, was completely medically unreasonable. And of course, the insurance companies go and they get all sorts of medical reports from these various doctors to try and create doubt. And when there is doubt, they argue it was a reasonable decision to not pay, even if it was the wrong decision. And that's kind of the path they take to win in these cases. We spoke about the limitations in the insurance policies. I'll briefly just mention, if anybody has a disability insurance policy, whether they're being paid, they're in the middle of a claim review process, or they're considering to stop working, one of the first things one has to do is to get the insurance policy from the employer. Take a look at the language in there, because there may be a limitation that says we don't pay for chronic fatigue claims of any sort. And it's a broad umbrella term that sometimes is used, and that encompasses MECFS. More recently, we see insurance companies applying the broad fatigue, chronic fatigue umbrella to long COVID, even though we've been arguing successfully that shouldn't apply. And then sometimes, instead of just a total exclusion of certain conditions, they would instead limit payments to only 24 months. One other thing to be wary of here is when the insurance companies get MECF related claims, they try to recast what is a physical disability into a mental health issue. And the reason they do that is because most of these disability insurance policies will only pay 24 months of benefits for disabilities due to mental health conditions. All right, so then the question is, against that backdrop, right, of the David versus the Goliath. Here we have the insurance industry. They've written these insurance policies in a way to limit payment or exclude payment. They're not using expert doctors purposely. They have all these legal incentives not to pay claims. We have an uphill challenge with this condition, right? But there is good news. If done right, these claims will be successful. And I'm happy to say, knock on wood, we've not had a single client who hasn't gotten paid here. So it's a testament to doing things the right way, the thorough way to get the job done. So how do you do it? Well, the first thing is, obviously, it requires close coordination with the treating team. There is no better source of medical information than that which the treating providers can give us. And that means having open and transparent conversations with the doctors, heart-to-heart conversations about what someone has been going through and that they have made the decision to take the step towards disability. And that's needed to build up the medical evidence. And then the other side of the equation after you build up the medical evidence is to build up the non-medical evidence. The non-medical evidence is what I call the human side of the case, right? We can look at medical records all day long. None of it will ever tell a story of what the person as a human being is experiencing. And that's a unique experience that most people cannot relate to unless they know somebody with MECFS or unless they have it themselves. It's very hard to communicate to somebody what it's like to suffer through this. And so we work closely with clients to build up the non-medical side of the case to tell their story. But on the medical side, what we've been doing is putting together what we believe is as complete and thorough as evidence can get with this condition. And sorry, I lost my slides. Okay, here we go. And so some of the things we end up getting would be a CPET, right? We'll talk a little bit more about CPET shortly, but a CPET is just a powerful tool to, as best as we can, objectively document a decline in functioning. The next thing is, if our client is having cognitive impairments, we have them undergo a neuropsychological evaluation, but not just with any neuropsychologist, a neuropsychologist who understands the disease process and know what to look for in this type of testing. When we get back the CPET report, we get back the neuropsychological evaluation report, we get all the medical records, we get a letter of support from the treating physicians. We get all of these records. We then send it off to an independent medical physician who's now tasked with reviewing everything and writing a report explaining why this person meets the criteria for disability. And this must be a doctor with the expertise in the condition at hand. Then lastly, when we get back that IME report, and there would be an examination if it's possible, then we send all of that back off to a final doctor who conducts what we call in the practice area and in medicine as well, a peer review. And there's a peer review of all of this. And then we really just kind of bring all the pieces of the puzzle together, because the way we construct an MECFS case is we look at it as a 100-piece puzzle, and you just have to get one piece of the evidence in at a time. The CPET, the neuropsych, right? All these pieces have to fit together, telling the same story, such that when we lay down all these pieces, you take a step back and you look at the puzzle, you now have a clear picture of what the person is going through. Part of that puzzle I mentioned earlier includes non-medical evidence. Those are things like symptom diaries. To the extent clients can, keep a diary, a log of the symptoms you've been experiencing. It can give a powerful portrayal of what a 2-week window might look like. There are also powerful evidence in the form of photos of videos. We had a client once who got married in a wheelchair because of the state of her physical condition. So we had the photos of her 2 years earlier at her engagement party where she was healthy, and then on her wedding day she was in her wedding dress in a wheelchair. Profound, very impactful. Again, this is touching upon the CPET. One of the things I wanted to talk about CPETs is years ago, a lot of the courts, the judges were not really putting any weight into CPET reports. It was almost for them like junk science. And so the insurance companies' attorneys would argue that's just not acceptable in the medical community. A lot of judges never heard of it. They don't even know what MECFS is. And they go, yeah, it's a bunch of hocus pocus. We're not listening to that. That's changing increasingly as CPET is becoming more widely accepted. It's also in court becoming something that the judges are looking at and saying, well, this looks like reliable evidence. So that's a good news here. Same with a neuropsychological evaluation. It's a wonderful test, as we know, right, for testing areas of attention, problem solving, memory, processing speed, a whole bunch of areas and executive functioning. We get a really good insight here if it's done by the right neuropsychologist. And we use those in every case where our client has some amount of cognitive impairment. This goes back to the peer review and the independent medical evaluations I was speaking to earlier, where we're consulting physicians who are experts in the field for them to examine our clients, review all the medical evidence, and give a strong medical opinion supporting disability. So where do we stand in terms of the law and what insurance companies are getting away with or not getting away with? Years ago, I'd say 10 years or more ago, insurance companies were winning a lot of these cases. And so what was happening is when they would deny benefits to folks and there would be a lawsuit, the insurance companies would then strong arm people into taking cheap settlements because they had a high chance of winning lawsuits. The tide is turning. And what we've been seeing is increasingly, as we educate the judges on this stuff, they're increasingly coming around and ruling in our favor across the country on this. And here is a case not too long ago against an insurance company involving someone who was struggling with cognitive impairment. And the insurance company says, well, that neuropsychological evaluation is worthless. We're going to throw out the entire report. We're giving it no weight whatsoever because there was one component, one of the reliability measures was off. Although the remainder of the report checked out to be just fine. And the judge in that case said, the judges in that case said, you can't do that. Neuropsychological evaluations, they're good tools for assessing cognitive impairment. If one part of the report might not be reliable, you can keep that in mind, but you cannot throw out the entire thing. 10 years ago, that would not have happened. The judge would have allowed them to throw out the entire report. So we're seeing a change. Here's another case. This was an attorney who was diagnosed with long COVID and CFS. 7 of his doctors agreed he was disabled from these conditions. The insurance company went and they got a few doctors with no background in these diseases. And they wrote reports saying he could function as an attorney, he could work. This is a good case because what it shows, this is around, I think this was showing that the judges were starting to understand the conditions a little bit more and rejecting the insurance company's rationale for not finding somebody disabled. Here is one more case. It's called Vastag versus Prudential. A person also had CFS. The person was a reporter for a major newspaper, and they had a neuropsychological evaluation and a CPET. And one of the things that we found to be very good about this case is the judges went back, this is back in 2018, they went as far as to say the CPET and the neuropsych is actually good objective evidence, good objective proof supporting disability. that defeats the insurance company's argument that there is no objective evidence. And I know we have medical objective evidence in the form of blood work and other things that over the years, all the research is heading, we're going in the right direction. But often is the case that the courts lag behind on that stuff. So when you see judges are adopting things like a CPET and endorsing it, that's a positive sign. If someone has a disability claim that was denied, it's incredibly important to prepare an appeal that goes through every aspect of the denial. It has to be a comprehensive letter that includes medical and non-medical evidence, such as the things I had described earlier. It's important to also point out during the appeals process that the person is being treated by doctors who have experience in the condition versus the insurance companies, doctors who lack any experience or expertise. And of course, if ERISA applies, one of the frequent questions we get from people who call us is, how long does insurance company have? How long can they take to review my claim? It's been months and months, and the short answer is it depends on the stage of your claim. But if it's an appeal to get benefits and it's ERISA governed, then they have 45 days. They almost always blow that deadline. In other words, almost always just violate the law. And that's where it becomes important to hold their feet to the fire by putting additional pressure on them to make a timely decision. It usually it can force their hand into finally capitulating and paying the claim. All right. So that was, I would say, a 10,000 feet overview on disability insurance specific to MECFS and, of course, long COVID as well. Happy to address anything else.
So thank you, Eddie. That was a very concise talk, and it explained really well the legalities of the situation. I also enjoyed that you gave examples. So to repeat for this audience, we're not using written questions, so feel free to raise your hand and I'll unmute you so you can speak directly to Eddie. There is already one question that someone put in writing, and they wanted to ask, is it necessary to have a 2-day CPET? I also want to comment that Stacy Stevens, who came up with the 2-day CPET, is in the audience.
Okay.
And Stacy can also say something too if she wishes, but go ahead, Eddie.
Yeah, that's cool. I'd love to hear what Stacy thinks. In our experience, it's better. If we could choose, absolutely 2 days would be a better way to do it. I think it makes for a more accurate representation of someone's true functionality on back-to-back days. The second day is when you're looking for that drop-off. And I think on the legal side, you get to show a judge, this is what we're seeing in 2 days. Could you imagine 5 days in a week and then repeat that the next week and so on and so forth? So it just tends to be a better piece of evidence. So if you can do 2 days, absolutely do 2 days.
Stacy, do you want to say anything? I'm going to unmute you if you want to.
Hey, Lily, can you hear me?
Yes.
Hi, Eddie, thanks for your talk and thanks for the question about 2-day CPET. I think a lot of patients are really worried about the post-exertional malaise and the rehab or the recovery time. There's a great poster that I think there's an urban myth that patients will never ever recover. The shocking thing is after doing this for 30 years, we rarely see that. I designed the protocol to show what happens during the post-exertional state. So the idea is to cause PEM. Half of our patients recover in less than 7 days. The other half takes 7 days or longer, but usually recover within 2 to 3 weeks. So there's always a risk versus a benefit. The benefit is It shows severity of illness, severity of functional impairment, and whether a person can work day in and day out. They may be able to go to work on Monday, but can they go to work on Tuesday or Wednesday? And this is objective evidence that can't be faked. And in the situation for disability, it's essential to have objective evidence that proves you're functionally impaired.
Thanks, Stacy. Any questions from the audience? Please raise your hand and I will unmute you. Well, I have a few questions. Oh, there is a question. So this is Dr. Allison Bested. Allison?
Hi, thank you very much. I was just wondering for our patients, can we order a CNS-VS or a central nervous system vital signs online cognitive program instead of getting an in-person neuropsychological evaluation to evaluate the person's cognitive abilities? Would that be suitable, or would you really need an actual neuropsychological evaluation in person?
Thank you for the question. I think where the state of the law is right now, a neuropsychological evaluation would be something that judges are familiar with and are faster to endorse. So it just makes for a better piece of evidence from a legal perspective. Yeah.
So you're saying it has to be in person and not online?
Yeah. Yes,
Okay.
exactly.
Okay.
Exactly.
Okay, great. Thank you.
And now we have a question from Tommy Fitzpatrick. So I'm going to ask you to unmute and then state your question.
Hi, I was wondering if you use QSART or tilt table tests or small fiber neuropathy tests as evidence that's objective.
Yeah, great question. Yes to all of it. Just more pieces of the puzzle. So absolutely. And I'd say many of our clients, many, not all, but many of our clients do present obviously with POTS and the tilt table testing confirming. So the more pieces of a puzzle we can get, then the better. This overall presents for a stronger claim.
Thanks.
I'm going to add on to that question. So Eddie, there were a bunch of studies by Dr. Peter Rowe and Drs. Visser and Van Kampen in the Netherlands. And what was interesting is that they showed 90% of the MECFS patients, even those with normal tilt table testing, had a 25% decline in the blood flow to their brain after 10 minutes. And so has anyone used that type of testing? They use ultrasound of the carotid arteries to look at the blood flow, or have you heard anything about that?
So I don't recall seeing that. I don't know if we've run into that. No.
I asked because ultrasound is safe. It's relatively cheap, and it's available all over the country because they often use that test to look for whether people are at risk for stroke or if they have a blood clot in their neck, that's causing the stroke.
Yeah, that's interesting. Yeah.
Does anyone in the audience have a comment on that? I think Nancy might, and then I'm going to go to Andrea because I know you had a question, Andrea, but I'll let Nancy. Nancy?
Can you hear me okay?
Yes.
Oh, great. Hi, and thank you, Edward, for that great talk. That was excellent. You did wonderfully. So there's this new device, Lumia. You're going to see it more and more in the coming years because it's a gadget that a patient wears in their ear that measures blood flow to their head. And it's very sensitive to orthostatic challenge. And it seems to correlate pretty well with cognitive function or brain fog. So a lot of patients are buying these devices and they have their own data. And then we're starting to use it in research studies a lot. So I think you're going to start seeing that. I think that the concept that perfusion really matters and we can measure that wherever it is a big focus in both long COVID and MECFS. So that's exciting because it's objective. It's hard to suggest to someone if you drop your blood flow to your brain by 40%, you wouldn't notice that. And that's the kind of numbers that that patients are seeing. So that's important. And the other thing that's weird with that device and with the ones that Lily was talking about, that's strange in ME/CFS and long COVID is not that, I mean, it is bad to have your blood flow to your brain drop, but normally if you lay back down, it should recover very, very quickly, and it does not. It takes a half an hour or an hour before they start having normal perfusion again. And that's really weird and very bad for cognitive function. So I think that we're getting a much better grip on why people's brains don't work. Maybe you might comment though on, because in my experience as a clinician, people will work themselves half to death literally. But the reason why they quit is when their brains stop working reliably. I mean, it's the lawyers 10 hours and working 70-hour weeks that have to quit lawyering, and the doctors that are writing the wrong doses on their prescriptions that have to stop doctoring. So perhaps you could talk a little bit about what is the most disabling and what can we best document to prove that it's disabling.
Well, what was the name of that device, Dr. Klimas, that you were?
It's called a Lumia, Lumia. It's relatively new, but lots and lots of people are grabbing it, and it's giving us some really good data.
And that's something that we can find online?
Yeah. It's commercially available. It costs about $300.
Yeah, I mean,
so,
for $300 to get another piece of objective evidence that you cannot fake.
Yeah.
That's well worth it.
That's what I figure. We're doing some validation work with proper research studies, but I think it's pretty impressive little gadget. That's really good. But I guess what I was saying, my question to you is a cognitive assessment. So cognitive testing, as you know, people rest up to go do their IMEs, which drives me crazy. They don't go on their regular day. They go on their very best day. They rest up so they can go impress these doctors that are going to say, no, you're not disabled. And what we do know is that these guys, as you said, they're not experts. So they see them just that once cross-sectional time. They don't realize that they spent the next 2 weeks in bed after their day in the IME office. And that is an important thing. So another thing to advise people to do is if they do get one of these terrible IMEs and they have to go, to, like you said, keep a diary, but keep a diary of what happens after you leave, that to be able to say, yeah, he saw me, and then look what happened to me.
Yeah.
That matters. And you've told me they can fight for true experts, so they don't have to accept the one that's given to them, right?
That's right. I mean, there's a way to push back. I think that's absolutely right. The problem we have sometimes is people usually get to us after an IME, and unfortunately, some people they feel as though the insurance company would actually use a doctor. That would be fair, and then they walk right into the lion's den, and the damage is done. But to your point of not doing well after an examination, one of the things that we have clients do is they keep that log that you were mentioning, and if they end up not doing well, that's typically what one would see. We prepare a really short affidavit for them to sign, or maybe a spouse or somebody who's been with them to sign, explaining what it has been like since we're seen for that evaluation. And then we have it sent to the insurance company and the IME doctor. So it forces the IME doctor to face what that person is saying and actually say, no, this is completely made up. This person is a liar, which the doctors won't, because they don't have any evidence that the person is not being truthful. And it would ruin the doctor's credibility to accuse somebody without evidence, right? Calling somebody a liar or a cheat, that's a big deal, right? It's called insurance fraud. So if a doctor is going to go out on a limb and do that, they better have the evidence to back it up. So they won't. But so often what they do is they just don't respond, and they try to ignore it. But we don't let them off the hook. We keep writing them. I mean, just today, we sent a 5th letter on a case where we're like, no, you need to respond. You need to respond. This was to MetLife. You can't keep avoiding the issue. And there's a point where they actually do end up responding, and then they have to back down. or they just ignore it forever. And then if you end up in court on it, judges don't like that stuff, right?
Yeah.
So,
The other thing I see, Eddie, in our patients is that the
Nancy,
insurance
can I
company.
just let one person ask a question? Because Andrea's been waiting
Oh, I'm so
patiently.
sorry. Yeah,
So
go
let me
ahead.
have her ask something and then go back to you. Andrea, did you have a question?
My question was, does attorney work with patients in different states?
we do. Thank you for the question. We have clients across the country.
Very good.
Yeah, no, my point that I was going to say, Eddie, is that what I see the insurance companies do from my end is exhaust my patient to the point where they're willing to accept the settlement. And then the settlement's usually for like about a year's worth of living. And now they got nothing. They're done. They got nothing at all. And that's happened over and over and over again.
So, Dr. Climas, that you've hit the nail on the head is the strategy of the insurance companies. Delay, deny, get them into a lawsuit context, exhaust them, force them into a cheap settlement. And so the solution to that is, the reality is, I don't know if people going through a disability from MECFS is able to take on the insurance company. What I can speak to is what we end up doing with our clients is we try to keep the client's involvement in the case to a minimum, right? Keep the just overall their footprint and what we're doing to a minimum. But then on the other side of things, what they're not necessarily seeing is there is just an overload of information and proof being sent to the insurance company. And eventually, you know what I see, Dr. Climas? The insurance companies will start off with our clients giving them lowball offers. And I tell the client, expect the low-hanging fruit. Please reject it. We'll walk you through the process. And if the client can kind of hang in there and allow us to do the things we need to do, eventually the insurance companies, they do end up paying a fair settlement to our clients, right? Every case is different, but the strategy is to know and believe in your case in the way that you've prepared it with the objective proof that you know the insurance companies know that they are going to lose. And you just have to reject the low-hanging fruit.
Now, I saw earlier that someone named Sherry wanted to ask a question. And so, Sherry, do you still want to ask a question? If you raise your hand, I will let you ask. I think she still wants to ask. I can find her. Oh, good. Okay. You can speak.
Hi, Lily. I just wanted to thank Edward so much for his presentation. My question actually was answered by Nancy. It was with regard to the device, the Lumia.
Great.
So I appreciate that. Thank you.
Okay. And now I'm going to go back to Dr. Bested. Allison?
Hi, yes, I want to say thank you very much for doing the work that you do. Your work is absolutely incredible. And I thank you on behalf of the patients that have dealt with you. And I think it's wonderful. So thank you so much. I also want to just ask a general question in terms of when patients are approaching a person like you, what percentage of a contingency fee is expected for patients? Because I don't think they understand that part of the process. If you could explain that, that'd be helpful. Thanks.
Yes, absolutely. First of all, and thank you to you as well, and Dr. Climas and everyone that's on the treating and research side. I don't think we would be where we are today without everybody. So the typical contingency fee is 40%, but we have not been really charging clients at a 40% rate in a very long time. We've brought the percentages down. And I think ultimately what the percentage ends up being, it could be anywhere from 35 to even 33 and 1/3%. And it depends on the complexity of the case and how much support we're going to have. So if somebody, for example, comes to us and we know, Dr. Climas or her team is treating them, it's a bit different because we know we're going to have very good treating physician support. And then it makes our jobs and lives a lot easier rather than, unfortunately, we end up having sometimes people who come to us and they maybe just are in the beginning stages of seeking out treatment. It's a more complicated case because they don't have a nice paper trail. They don't have the right type of doctors treating them. There's a whole lot of legwork that we have to do. So we end up having more risk. It tends to make the contingency fee around that 35% or sometimes even 40%. But again, we haven't done 40% in a while. And I should clarify also that that percentage applies on when the benefits are approved. So it's the initial payment from the insurance company. Then we continue to represent our clients, but we don't keep that same percentage. The percentage drops, and it drops from anywhere from 20 to 10% from the monthly payments. And this brings me to one last really important point. I tell everybody, once approved, not always approved. The insurance companies are going to continuously review disability claims, and they always have an eye towards terminating benefits. So it becomes really important to continue doing a lot of the things that got the benefits paid in the first place, and to remain vigilant to avoid termination.
I have a question for you, but first I want to see, does anyone else have a question? Please raise your hand. Anyone? So my question is, earlier you talked about how judges are increasingly accepting different pieces of evidence. Is there anything we can do at IACFS ME or other people can do to help educate them more?
Wow, that's a good one. I think the harsh reality of what we see is just in general, everybody's attention span is just not there, right? We're living a very distracted world. So I think with these judges, they have a full docket of cases.
Mhm.
And the only time you get these judges' attention is when it's your case in front of them in that moment where you have to make a decision on it. So there's not really much of an opportunity to reach out to the judges to educate them on MECFS until you have that case at that point in time. And ideally, what we want is by the time it gets to the judge, we have an insurance company's claim file that's chock full of good, solid evidence on disability that we then get to explain to the judge what each of these pieces of the puzzle means in terms of proving disability.
Have you ever seen judges like the same judge twice before? And have you seen them increase their understanding or change their minds?
Yes, absolutely. And I think one of the things I'm seeing is when you see some of the judges over and over again, they start to associate me or my firm with disability attorneys with a very deep knowledge on certain medical conditions. And so I think subconsciously the judges start to defer to us a little bit more than to the insurance company's attorneys who don't really have an understanding on the medical condition. They were not involved in the legwork that we as attorneys did for the patient. And instead, they only stepped into the case when it was in court to try and defend the insurance company's denial. And I think judges are starting to see the dynamics there.
Mm-hmm. And I think the last question goes to Dr. Bested, unless there is anyone else.
Hi, thank you very much. I'm initially from Canada, and now I'm an American as well. But in Canada, there was an Ontario Disabilities Lawyers Association, and I was asked to speak at that with the idea that I would be educating the disability lawyers who eventually may become judges. Is there something similar to that here, maybe in Florida or maybe more of a United States sort of lawyers association? Because that might be a way to educate other lawyers about this particular illness.
Yeah, and what was the name of that association?
It was the Ontario Disability Trial Lawyers Association.
Trial lawyers, yeah.
I think so, yeah.
Yeah. So I think that's a great question. So we have the equivalent being the AAJ, American Association for Justice, which is nationwide, and it is the largest plaintiffs justice association in the United States, and a lot of attorneys in there do end up going on to being judges. And then you also have the ABA, American Bar Association, which isn't limited to just plaintiffs' attorneys, but also defense attorneys. So you have somewhat of a broader reach. Those are two organizations that I think might be a good a good place to maybe have a good reach to reach out to some of these future judges on these things.
I
That's a great
I spoke
question.
at a day that was dedicated just to this, and I think it helped to make a difference. So maybe that's something you could be involved in the future to try to get something as an educational topic for the lawyers.
Yeah, and I'm thinking as you're speaking, I'm thinking in my head about that, and they have annual conferences, and they put conferences on a whole bunch of legal issues, and sometimes these organizations will bring guest speakers who are physicians, and the physicians will talk about specific medical conditions and how it ties into a case. So I think there has to be some kind of a connection in that way for them. But yes, I do agree with that. And maybe we should talk about it to see if
I think many
there's
members
something.
of our association would be open to doing something like that, if it was organized by someone with your background, Eddie, in the
Yeah,
legal profession. Any final questions, anyone, or
great idea.
comments? Okay, great. Thank you for taking the time today to have this conversation with Eddie, and thank you everyone attending for that lively discussion. That was very nice.
Thank you, everybody.
As you can see, all these people are giving you a applause as they can. Yes,
Too kind. Thank
yes.
you. Great questions.
Anyway, feel free to leave. Tomorrow we begin our program again at 9 a.m. Eastern Time on Track 1. Have a good evening, Eddie and Bryn. And I am going to stop the recording and then the meeting.
Thank you, Lily. Thank you, everyone. Take care.